Separation of power in practice. From a historical perspective, the characteristic of British constitutional arrangement is bipolar, and this has been argued by Tompkins. He states that the English-style separation of power is confrontational, bipartisan, bipolar. Crown and the Parliament are the only two powers the Constitution has ever recognized as enjoying any degree of sovereign authority. Every constitutional actor falls on one side or the other of this great divide. In that, all constitutional actors ultimately draw their power from either the Crown or from the Parliament. Going back to the parent-institution analogy of the Crown and Parliament, the two institutes can be seen as parent institutes, providing the foundation for all the constitutional child institutes. It can be seen evidently from the process of approving an Act of Parliament that includes at the very end obtaining the royal assent from the Crown. That can be considered a parent institute playing its grandfathered role. Tompkins puts it beautifully that an Act of Parliament is the legal moment when the two sovereign authorities of England comes together and agree. Parliament on the one hand and the Crown on the other. Can you see a problem in this description? Or to put it another way, can you tell which one of the governmental branches have been undermined in this view? Let me give you another hint. If you are studying law, which constitutional actor will you be most interested in knowing? Is it the legislature, executive, or the courts? The answer in most cases will be the courts. This is a direct criticism of a bipolar view of the constitutional arrangement because it undermines the role of the courts. A Tompkinian can argue that the courts and the Crown have strong symbolic and actual ties, and the ties are evident from the royal coat of arms symbol hanging behind the judges in the courtrooms. On the other hand, an Advent critic will point to the Judicial Appointment Commission and the enhanced role of the judges in the post-Human Rights and Constitutional Reform Act era. We will study these phenomena in more detail in coming lectures. For now, let's just focus on the doctrine of separation of power and some practical and interesting ways of looking at it. The first scenario deals with the articulation of a social value that deals with punishing criminals in our society. It reflects how separating the powers of adjudication and legislation is a good idea. The case deals with sentencing. Keep in mind that the purpose of the punishment is not to revenge the death of an innocent, but to rehabilitate the wrongdoer. Who do you think should have the power over this decision? Should it be a politician who is influenced by the popular vote and may react differently depending on the popularity of the issue? Or should it be a judge who will not be influenced by the popularity of the issue? In R versus Home Secretary 2002, Anderson, a life prisoner, brought a judicial review against the Home Secretary because the Parliament had altered the powers granted to the Home Secretary. The House of Lords decided that under Section 29, Crime Sentences Act 1997, the Home Secretary is carrying out a sentencing function. Since sentencing is part of the trial for Article 6, Subsection 1 ECHR, it should be carried out by an independent and impartial tribunal, which the Home Secretary is not. The House thus issued a declaration of incompatibility with respect to Section 29 of the Crime Act 1997 using Section 4 in the Human Rights Act. Lord Steen raised a very clear line of reasoning stating that the separation of power principle is essential in the constitutional arrangement, but the paramount constitutional principle is the supremacy of the Parliament. The Parliament had clearly delegated the powers to the Home Secretary. The question was that whether the Crime Act 1997 was compatible with the Human Rights Act 1998 and in accordance with the fair trial principles of the ECHR Section 6. He also found a historical argument from Blackstone's commentaries on the laws of England stating that the act of sentencing has been done by the courts. The case shows that how the supremacy of the Parliament is the core constitutional principle. However, there has been common law precedents that depict separation of power, or to put it another way, separation of the role of governance between different institutions of the government. The second scenario represents the separation doctrine from the point of view of the executive branch. Tony Blair's government was seeking reform, so the task was assigned to the Department for Constitutional Affairs. The department argued that the court decisions taken by the House of Lords are actually made by the Appellate Committee of the House of Lords, But this is not very clear from the current structure of the courts. The department showed concerns for the dual role of the appellate judges, both as policymakers in the House of Lords and justices in the appellate committee. The overarching role of Lord Chancellor was criticized. The department argued reforms on the basis of the Human Rights Act that had incorporated fair trial requirements of Section 6 of the European Convention on Human Rights in the UK. We can see that the fair trial requirements from outside the UK have paved the way for an independent court. We can apply Montesquieu's argument here that liberty can only be achieved when there is a clear separation of power. Can you find a case where the public officials have acted in a way that was contrary to the civil liberties of the citizen, and the court had reminded them that the power of the executive is limited? Lord Camden stated in Entick v. Carrington, 1765, that the state may do nothing but that which is expressly authorized by law, while the individual may do anything but that which is forbidden by law.